Good afternoon, it's Alex Woods here reporting from Warsaw, the financial mis-selling district of Warsaw in the Regis Business Centre, and this is kind of like a double-sided question, the first side of which I've answered in a previous video posting, and I'm now taking the contrary position, if you like, which is, in short, let's just say you are in a position where you have bought the property, you have made the lion's share of the financial contributions to that property, the relationship is ended, it's perhaps ended some time ago, and you're now looking to remove your ex-partner from the deeds and move on with your life. So this is looking at the situation from the reverse situation from the one that I looked at the previous video posting. So I'm going to summarise the facts of this particular hypothetical example, and this is almost a hypothetical example. It's a very typical case. I'm then going to sort of take you on a whistle-stop tour through the law and apply it to the facts of this case, before coming on to really the key question, which is, does getting legal outweigh the, do the benefits outweigh the disadvantages? Instructing lawyers, threatening legal proceedings, actually issuing proceedings, is it worthwhile? So that's what that's a key question you should have your radar running for. So don't fall asleep over your cup of coffee, but hang in there. And then the final section will be, to wrap up and to conclude, and apply it to this specific example, because at the end of the day, every case will be different. This, although hypothetical, is very typical, and the usual caveats apply. This is only general legal advice. So anyway, let's get started with the particular facts of this case. So, a lady, she bought a house in 2006. She put down a deposit of £10,000. The value of the house at that time was £100,000. Mortgage was £90,000. Her partner moved in with her. She put him on the title deeds. Having initiated the purchase of the property herself, she put him on the title deeds, and he then made contributions to the mortgage for 2 years. And then after 2 years, he left. And indeed, let's give this some colour. In this typical example, let's assume, which is often the case, that the ex-partner has pretty much vanished from her life. Indeed, often has gone overseas, perhaps has set up a new life, perhaps has bought their own property and moved in with their own partner. So that is, broadly speaking, the scenario. Now, the key question is, before you even begin to consider legal proceedings and such, and actually before you even consider negotiating and making any sort of approaches to your ex-partner, really the key question is, what does the law say in England and Wales? This is obviously example is where the property is, where the jurisdiction is in England and Wales. So what does the law say? And as people will know from me soapboxing on the subject in previous videos, it is not like being married. There is no such concept as a common law man and wife in this respect, where property is involved. The Matrimonial Causes Act is irrelevant. The key question will be, what is the common intention of the two parties at the time they entered into the relationship in respect of the property? That will be the key question. Now, let's apply it to the facts of this particular case. Now, on the face of it, this looks like a problematic case for our lady. She's our client. Because, as we all know, there's a presumption, a legal presumption, that where you put your name on the title deeds, you are in effect gifting your partner 50% of the property. It's a joint tenancy. Furthermore, where the property was purchased post 1998, there's actually a declaration of trust box on the document that you register with your interest in the property with the land registry, And that's giving you an opportunity to say how you would like the property disposed of otherwise than in joint shares. And in the particular case, this prevails. There was no declaration of trust box filled in. So on the face of it, the legal position looks tricky for our lady client. However, there are two key features that make me pretty confident, and I use the standard of more likely than not, the standard that the court would use in finding in her favour. I would say it's more likely than not that the court would not make a 50-50% split, but would give her a larger share. And the two key factors are, number one is the fact that she has made greater financial contributions. Now, if you look beneath this video, you'll see a table, and I've split out the financial contributions, 10k a deposit. They've paid equal mortgage repayments to 2006, 2008, but she has paid a maintenance because she, in this example, took more control of the property. She purchased the property. She's made a slightly bigger contribution to maintenance. Anyway, have a look at the table. That all lays it out, and basically you end up with an 80% to 20% split in her favour. If you look purely at the financial contributions that were made whilst the relationship was alive, 2006, 2008. Now that's the first factor, but I'm afraid, as we know in this area of law, it's not about the pure financial contributions. Both direct and indirect contributions are relevant to the decision that the judge makes, and it envisages a situation where initially one party may be paying more, but later on during the course of the relationship, hopefully a lifetime relationship, the other party may bear their share of the financial burden. So the courts won't automatically use, far from it, a financial yardstick in this respect. So I actually think, although it's kind of persuasive, it's probably not enough to overturn the presumption of 50-50 and the fact that she has gifted him half the property by putting his name on the title deeds. However, we come on to the second factor in this case, which is that he pretty much walked out of her life in 2008, and we're now in 2015. So in that situation, that's, I think, quite a different situation altogether. And what is so interesting is we have, surprisingly rarely in common law, a very good case precedent to show that the courts are prepared to find that the common intention, which remember is the yardstick in this area of law, might have changed. And it probably did in 2008 when he left. And in this case, he left the country and went and set up a new life and couldn't be even traced by the lady client in this instance. So it's very likely that at the point of the relationship broke down in 2008, a court will find that the common intention changed, i.e. it was no longer the intention of the parties that that property be shared 50-50. So it's a rather neat case in many ways. And by the way, the case that I referred to is below, so you can look that case up. I've given details underneath this posting. And the courts are quite prepared to make percentage splits other than 50-50, where the presumption of joint ownership, 50% ownership, is overturned, as it is, I believe, in this particular case. So, there it is. It's quite a neat case, as I say, because I think, on the one side the court will be saying, well, she has borne the lion's share of the contributions initially. Then again, he's made a contribution too. He helped with the mortgage and helped with the relationship and living in the properties together. So, no, I am minded on balance to say 50-50. But then, hang on, the relationship broke down in 2008. He's no longer making any contributions to the mortgage after this time. Is kind of like freewheeling or, what's the word, sort of riding shotgun on her work in terms of expecting a share of the property when it's ultimately sold, let's say, in 2015. So, In short, my conclusion on this first key question of what what the legal position is in respect of this particular case is that she is probably likely to achieve as much as 75% equity in the property. And I've broken down the maths there. You can see it. The court will say, what was the property worth in 2008? I've assumed 150,000, probably much more than it actually was. So it's quite conservative. She might get more, but using a conservative yardstick of 150k, he gets 30k, and she gets around about well, that is approximately 25% of the equity in the property at that time, give or take. So anyway, so that's the situation there. She's on strong ground. The question of whether a court is likely to order a sale is one I'll quickly deal with. He may feel that, well, I don't want to sell the property. I'm quite interested in enjoying rent, so I want to sell it at a later time when it's likely to have higher value. What will the court say about that? Well, pretty straightforward. This isn't a business relationship. This is a cohabiting romantic relationship. It's not going to go with that argument. They're not business colleagues. They're going to say that the relationship has ended, and therefore, within a reasonable time frame, they'd expect that property to be sold and the proceeds to be dispersed between the parties in those respective shares. So I'm now going to come on to the real key issue, which is, do the benefits outweigh the disadvantages if you go to court? Do you get legal on his arse? So the first thing to say is that, and I will just also include this issue of what steps should she take. The first thing to say is that it's a little bit of an uphill struggle. She's confronting an ex-partner who can simply do nothing and require her to spend money on legal fees and disbursements, court fees, perhaps counsel's fees if counsel's advice is required. And court fees are a particular stinger. In the respect of court fees, they've gone up massively just recently because the government is now trying to get claimants to pay for the justice system. And in this particular example, she could be looking at having to find as much as £5,000 just to issue the case. As we often know, as lawyers, people don't start to respond seriously and engage with a complaint. That's it, over and over and over again, until they get a letter from the court saying proceedings have been issued against you. So there's sort of something of an uphill financial struggle that the client has got to go through. Now, I will just say that by the same token, if she's actually laid out followed the proper steps prior to issue, it could ultimately end up working in her favour. So what do I mean by that? Well, basically what I mean is that, and this is what she should do if she's faced with this problem. She needs to take legal advice. Unfortunately, the law is not clear in this area. She then needs to engage with her partner and try and settle the matter without recourse to legal proceedings, obviously. She needs to state her position. I think I'm entitled to 75% of the value of the equity of the property. I think that the judge would make a finding that in 2008 the relationship ended and the common intention changed. So she should lay that out in a letter so he's clear that she's taken legal advice and she's now telling him what the findings of that legal advice is. She may then need to instruct a lawyer if he ignores her, and then that lawyer will write a couple of letters. He may then, that may not be enough. She is then looking at issuing legal proceedings. And the key thing here is she wants to make sure she protects herself against the cost of having to pay the other side's legal bill. and potentially recoup her own legal costs from the other side. Now, the key thing here is she should make a realistic offer. If she makes, and it would quite possibly would be what's called, it's a technical term, but it's Part 36 offer, but it means it's not like a normal bartering situation where one person goes there and then they go there and then you meet in the middle. This is a technical approach, an intelligent approach that the courts adopt. The claimant is required to make a realistic offer before issuing proceedings. Now, in this case, I would say a realistic offer would perhaps be 33%. This is a general case. There are many different factors that might apply, but in this case, all other things being equal, I would say 33% would be a good written offer that she should ask her lawyers to make to the other side. Now, if he doesn't take that, then the tables turn. Particularly if she's prepared to instruct her lawyers on a no-win, no-fee basis. Because, of course, the principle of the litigation, civil litigation in the UK is the loser pays the winner's costs. So if she gets 25% after she's issued proceedings, he'll have to pay all of her legal costs as well as the money. You can see how now legal costs in a case like this, going all the way to trial, could be £25,000, could be more, could be £10,000 just to get you past the starting post of issuing proceedings. Don't forget, issue fee alone could be £5,000, could be £12,000, £15,000. But now, look, he's £30,000 that, if he'd been intelligent, he would have taken before proceedings are issued. It's now in real danger of being gobbled up. And the judge, or even at an earlier stage, if he then decides to settle after issue but before trial, he's then in a very great danger of losing a lot of his equity in legal fees because she's been intelligent enough to make a realistic offer of 33%, and she's beaten that. Let's say she gets 25%, let's say she gets 32%. She's still beaten that realistic pre-issue offer. So you can see how it's kind of a strange sort of a way the tables can turn in her favour, and indeed she may then go, if he fights and goes all the way to trial, get 25%, get her 75% rather than 66, and have him pay her legal fees, and then that's not what you'd want to achieve because there are sensitive emotional issues around the breakdown of a relationship. But at least she knows that if she does have to get heavy, ultimately she is in a good position. So I will just now touch on, and I think I'll, in order to keep this posting relatively short, did you want to get to your? Yeah, please go ahead. Just to keep this posting relatively short, I just wanted to conclude on, this key question of whether or not to instruct a lawyer. Basically, does a lawyer add value? And in particular, upon what basis should you instruct your lawyer? Should it be on an hourly rate basis, or should it be on what's called a no-win, no-fee basis? So let's look at those two examples. Now, if you are taking matters forward on an hourly rate basis, of course, the danger is that you're in essence, as I've said before in a previous post, getting in a taxi with a meter running and not knowing how long the journey is. So you could find yourself, if he's a belligerent gentleman, issuing proceedings, having incurred £12,000 worth of legal fees, which is going to make a bit of a dent in your ultimate winnings. So that's the danger, if you like, of hourly rates. On the other hand, perhaps he may settle and see sense very quickly, well before issue, and you could be out of pocket to legal fees of £2,000, £3,000, £4,000, £5,000, let's say. You can kind of see how the kind of a key issue is the extent to which you think he's going to be cooperative. So now and of course, if you do get on an hourly rate basis and he's not cooperative and you have to issue proceedings, you're then facing an escalating bill. You're facing both your own, and it's a cash flow issue. You've got to find that money to pay the lawyer as you're going along. You're then faced with an escalating bill, and you're faced potentially with if things don't go according to plan, and there's always an element of risk in any litigation. You don't know what a judge is going to say, and in these cases, in this area of law, it's not, the law isn't set in stone, so there's arguments to be had. You could end up having to pay the other side's legal bill if you lose, and that is not a very attractive proposition. So that's the danger of the hourly rate approach to disputes of this nature. With a no-win, no-fee approach, and I declare an interest in this, I have experience. I can do hourly rate, but I have experience, considerable experience of running no-win, no-fee cases and cash-flowing litigation. You are insulated against that because from the very early days, the lawyer says to you, I've looked at your case. You will need to put some money up front, incidentally, typically £1,500 the last time I did a case of this nature. Once the lawyer's looked at your case and decided that it has real merit, then he'll jump tracks onto no-win, no-fee, but he will be taking a percentage of your winnings, and that could be, I've used in this example 15%. It could be 25% is quite typical, and you can then see how you are, if the matter does settle very quickly indeed, then you've lost 25%, and you kind of could have used the hourly rate system, so that's a disadvantage of it. But it does remove the risk, because there's something kind of unique about proceedings of this nature where you're faced with a difficult opponent especially. They kind of almost know from the day one whether or not you're serious. And if a lawyer is on a no-win, no-fee arrangement, he's going to put a lot of effort, and he's going to take a contingency of up to 25%. He's going to be putting in a lot of front-end work to finding out everything he can about your case to make sure it's really watertight, and then really hitting the opponent hard. So whereas an hourly rate lawyer isn't so invested, he can just write letters and take instructions and bill you as he goes. So there's perhaps something quite interesting and entrepreneurial in the no-win, no-fee arrangement, but you will be losing up to 25% of your winnings. So that's how it works, and of course with no-win, no-fee, for those who aren't aware of the system, as well as cash flowing, the proceedings, that's the price that the lawyer's paying. That's the price of the 25%. That's the price the lawyer's paying for taking 25%. He'll cash flow proceedings predominantly, if not entirely, and he will pay for insurance to protect you against having to pay the other side's legal bill if you lose. So I've put a table down there, and there are all the facts and the figures, and it's quite interesting. If you see, to take this particular case, it's only just on balance worthwhile instructing a lawyer on a no-win, no-fee basis, on a 15% basis in this case. Perhaps £10,000 is the difference, and don't forget all the hassle of having to get legal. Perhaps in this case there's an argument to say it would be simpler to just try and settle a 50% split with the other side. Although I would say that the lawyer will probably add a bit of value. For example, he may be taking the 10k deposit out of that 50% split. And don't forget, in this particular example, we valued the property in 2008 at 150,000. I think probably 130,000 might be more realistic. So you've got to do your maths on this. This is just a general guide example. So I think my conclusion is, and if we come back full circle to the subject matter under discussion here, which is the breakdown of a relationship, there are going to be emotional factors at play, probably, and you can't ignore them. And ultimately, the decision you make on how to proceed with your matter, with your dispute, might rest on whether you think your partner is reasonable and is cooperative and is going to try and arrive at an amicable settlement. If they are, then an hourly rate is probably, a small amount of hourly rate is probably on balance the better way to go. Okay, well, many thanks for your time, and I'm doing some more posts in this area to cover different angles on this general issue of disputes, cohabitation disputes, and the law of common intention around them. Many thanks.